Hello, everyone. Good morning and welcome to FGV Law. So I want to start the second day of our conference, welcoming our partners in Belém from Silveratias. We are grateful to have you as a host venue in Belém. Also, Pace Haub Law, Elisabeth Haub Law, School of Law at Pace University, our partner on this event. It's a great pleasure to have this joint event. I would like to remind that the event is filtered now dance online as well. So thank you, the audience online, for being with us today. So I would like to remind that it's a joint event inside the event of COP30. So we are organizing this in partnership with Elisabeth Haub Law at Pace University and Silveratias. Thank you to all the sponsors that are here, and a special thank you to Alessandra. He is here in person in Rio de Janeiro represents the Climate Law Initiative. Dr. Márcio represents BMA Law Firm, and Professor Ryan Roberi from Georgia State University, and Professor David Cassuto represents the Pace Hub Law, and to all the team of FGV. So to start these welcome remarks today, on the second day of this conference, I'd like to introduce Dr. Pedro Bentes, partner and founder of Silveratias Law Firm, our host venue in Belém. So Dr. Pedro Bentes, you have the floor. Thank you for your partnership in this initiative. You made your speech, and now your floor is yours. Thank you, everyone.
Okay, good morning, everyone. It's very nice, and in behalf of our law firm, we would like to welcome once again to this second day of discussions. I'm quite sure that we will have an excellent day of dialogue, considering the high caliber of the panelists, the diversity of the institutions, and also the multidisciplinary nature of the approach. For myself, I would like now to point out from the first day of the meeting, the third and the fourth panel. The third panel yesterday was cities and climate change, taking the actions needed. And the fourth, indigenous peoples and traditional communities addressing the climate change. I do so to emphasize and praise the organization of the event, how important it is to match the themes discussed yesterday with the panels today, especially concerning to the service of justice on the first panel, the role of judiciary in the climate agenda, with the fantastic and indispensable participation of the public attorneys. I see Julio here, which is a pleasure, be welcome, and the public attorney's perspective on the climate change agenda. It's important that he will be in the first panel, but he also has the view of a public attorney and the vision of how the state advocates on climate and environmental issues. And also, in the private attorney's participation here represented and very well represented by the president of our bar association, our batonier, Sávio Barreto, on bar associations and lawyers, ensuring that climate duties are fulfilled. Why this match, for me especially, is very important? Because first of all, I teach civil procedure law at the University of Pará. And second of all, I'm the head of litigation of our firm. And so daily I face constant conflicts and claims involving environmental issues. It's more than legal conflicts. We can understand the urge of communities and corporations trying to match their interests. And those conflicts occur in industrial areas near cities. That's why I made the reference to the panel on cities and climate change. And most of all, in our huge state, on the rural areas, on this immense state. Very hard to comprehend sometimes because of the diversity of the population that we have and the situations on mining, on businesses in general. And that they must be resolved. That's the classic problem, the dilemma, on the perspective of sustainable development, because we need to protect, we need to pay attention not only to the urban population for the comfort of the development of the urban population, and most of all, we have to take care of development for the indigenous communities and traditional communities, including riverside communities that you must experience going to Kombu, for instance. We are surrounded by rivers. The rivers are our streets. The rivers are our roads. We have the pleasure as being a kid to swim in the river. So it's very important for us to protect indigenous communities and all the traditional communities, including Riverside. The question is to know, how do we protect them? If we just keep them untouched, or we would allow somehow that nearby some companies or activities should be taken place. It's a very, very, very difficult choice. That's why, and Julio probably might confirm that all these conflicts go to the judiciary power. They go to the judiciary power through public actions, public class actions. But the most important thing on those public claims is the collective form that they assume. And not only that, especially those collective conflicts, they show up through a very specific type of process, which is the structural process, which is increased in number and intensity on our region. The structural process aims like to correct the unconformity of certain situations concerning to environmental issues. Very different kind of process, and it's even different for us and important for us because it is conducted under the principles of cooperation and collaboration, which is established by our Civil Procedure Code. This structural process in collaboration and cooperation basically is characterized by the essential participation in due process and participation for the best outcome. For that, I'm closing, it's imperative to enhance the participation of all stakeholders, expanding the dialogue with the impacted communities under the management of managerial judge, with the view, and I think it's very important, that the process is an arena for public debate, and the judiciary as a plate for public discussion under the active coordination of the judge for the adoption of a public consensus solution to legal dispute that fosters more appropriate outcomes. Let us all have an excellent day of discussion today. Thank you.
Thank you, Dr. Pedro Bentes, for your speech, for introducing our day today. So I would like to turn on to the Zoom. I would like to introduce Dr. Michael Wilson, who represents the Supreme Court of Hawaii. Dr. Michael, can you hear me? So the floor is yours.
Yes, I can hear you. I can hear you very well. Well, bom dia to Irmãos and Hermes my brothers and sisters in Brazil, and this is a great privilege to be able to address this group that includes a couple of the great environmental law professors in the United States, Professor Koo, and as well as David Foreman, who's my colleague here in Hawaii. And then Luke, aloha. I miss you. I haven't seen you for an awful long time. And you definitely are one of my heroes. I will confess that my perspective comes from that of a judge that has been involved in these climate issues for over a decade. And one of my teachers has been Minister or Justice Antonio Benjamin. So that has somewhat shaped my thoughts. And from that point of view, let me move on to the slides, because I am interested in certainly getting the perspective of all of you as to what is represented here. But from the perspective of a judge and our esteemed moderator, and who is a practicing lawyer, as I was for quite a long time before I was on the Supreme Court in Hawaii, has alluded to this very important role of judges. You know, judges are not consensus makers necessarily. They have a duty under the Constitution of their countries to enforce the law. So for example, the idea of sustainable development was something that was applied in a way that was considered atrocity law in the United States with slavery. You know, the idea that the economy needed slavery was the reason the United States Supreme Court originally decided that slavery was constitutional. Rather shocking concept, but I'm going to analogize that to what's happening now. You know, sustainable development didn't apply when our court found there was a right to a life-sustaining climate. The point was that we have a climate emergency, and our court had a duty to act to prevent development, not allow development that was in violation of the right to a life-sustaining climate. So my points of discussion really focused on this concept that climate emergency law, contemporary climate emergency law, compels judicial protection of the right to a life-sustaining climate. This is a pretty straightforward proposition in different parts of the world, but not necessarily in the federal courts of the United States. And I will focus on that to an extent. And our state of Hawaii, you can see a bit of Hawaii behind me. This is where my beach house is. And I suppose the most memorable part of my presentation is that I'm inviting all of you to my beach house, and it would be a great privilege to have you there. And I have had some great friends, including Minister Antonio Benjamin at the beach house. So please come if you can. But Hawaii is the bleeding front line of climate change in the world, along with places like India. And our state is the foremost champion of climate rights among all states. And we have, in a very straightforward, direct way, rejected the analysis of the United States Supreme Court majority on the issue of climate rights. And it's really important in putting in perspective the role of a judge to understand that in the courtrooms around the world are the giants, these corporations that are now wealthier than any corporations have ever been. And I'll talk about that. But they are the most formidable force affecting climate emergency law. And to some extent, their practices are being moderated by courts, but their ultimate decisions about how to approach the climate emergency law are something that will decide the fate of future generations. So we are the most remote landmass on Earth, and this will give you an example of how remarkable Hawaii is and why you should come visit. This is the most important beach of my life, where I went in high school, and it will be gone in about 40, 50 years. It'll be washed away. And these are the treasures of Hawaii. And certainly the birds will be gone in 40 or 50 years, but maybe the dolphins and the whales will survive somewhat. Again, this is an example of the present. That's where my beach house is, and that's coral. So the coral will be gone in 40 or 50 years. That's the most important resource in the ocean here in Hawaii. So at a broad level, I think everybody in this audience knows that sustainable development has been a failure. The COP process has been a failure, according to the United Nations. This was their 2023 analysis that said sustainable development has failed and we're on the brink of a climate catastrophe. And the reason is, of course, because of the nature of the emergency. Our solutions, and a judge has to always focus on solutions if they found there's a violation of the law, are quite limited because we have a limited solution horizon, a limited time to be able to reduce greenhouse gas emissions and keep the Earth from heating up to 1.5 degrees over and over and over again. This data point is in lawsuits. Certainly it's in our decision talking about what it means to have a right to a life-sustaining climate. And as you know, I think you know, the South Pacific part of the world is going to be essentially removed in 40 or 50 years as the Earth heats up above 1.5 degrees because sea level rise will force the population to move. This is where we're headed. And in Hawaii, and I would submit in more and more courts around the world, this is illegal. You can't have a policy that heads in the direction we are headed to now, which is 3 degrees during the time of our children's lives. This is an iconic statement worth understanding from the point of view of judges. We are not able to say that things are okay. We are not able to determine that sustainable development means we always have to make sure there's a consensus where development survives. In this speech, Secretary General of the United Nations was comparing the climate emergency to the COVID pandemic. And he spoke about how the pandemic pales in comparison. It's much less serious than the climate emergency. And that's pretty strong words from one of the world's leading diplomats, that we are on a highway to climate hell. Well, we certainly understand that in Hawaii. When you come to Hawaii, I'll take you to this beach. It's an amazing place, but it will be gone in 40 or 50 years, along with $2 billion in economic return. So why is it that this is happening? It's not because we don't have technologies that can allow us to reduce greenhouse gas emissions. And this is, again, a core data point that arises from the International Energy Agency. But in 2021, much, of course, after the Paris Agreement in 2015, in 2021, Exxon's profits were $23 billion. This is just an example of the enormous wealth that has been created during the time that we're supposed to be reducing greenhouse gas emissions. The next year after 2021, the profits of Chevron increased to $59 billion. So the consequences are that the influence of the oil companies has stymied or held up or interrupted the efforts of government at the legislative and executive level to come up with a climate protection plan. As you know, right now, there's no climate protection plan. And in the classes that I teach, the students that are willing to say that they have confidence in government or that there's hope, ask the question, what's the climate protection plan to reduce greenhouse gases? There isn't one. This is in large part why. The status quo works really well for the greatest, most successful business model in history. And approximately $20 billion has been paid to fossil fuel companies annually in direct subsidies by the US government. Despite their profits, this is the kind of subsidies that they receive. So in my class, this was an image that was created. to try to explain the reality of what's going on in the courtrooms of judges around the world. You know, you have cases that are being brought by mothers and children that are becoming more and more successful, but it's a difficult proposition to go up against this extraordinarily powerful community of fossil fuels. And you can see you have an indigenous person or a climate activist on the left holding the gavel, meaning the rule of law, which can have so much effect and has, especially in Hawaii. You know, our legislature is the only one in the United States that declared that there is a climate emergency, and we're already experiencing untold suffering. Antonio makes this point all the time, that the single most important legal issue facing judges globally is climate change. Again, partly because the executive branches and the legislative branches have not been able to even come up with a plan. And this is something that's affecting all areas of the law, and the opportunities for young people to participate as lawyers, as Professor Nicholas Robinson from Pace University has famously said. So there you go. We have over 2,000 cases. 40 years ago, there weren't any cases, and they're mostly being brought by children and youth in courts. So let's talk briefly about the courts internationally, and particularly the United States, since the federal courts of the United States are the courts that constitute the biggest threat to the welfare of the planet of all courts. And this is the decision that's the most famous decision in the United States, the Juliana decision, where the judge who found there's a right to a life-sustaining climate, the federal judge, knew what was coming. She knew her colleagues would reverse her. And she pointed out in her decision that federal courts too often have been cautious and overly deferential in the arena of environmental law, and the world has suffered for it. And she found that there is a right to a climate system capable of sustaining human life. And when she was reversed, there was a notable, now famous dissent by this wonderful judge, Josephine Staten, that said the federal courts were just throwing their hands up in refusing to provide relief where the survival of future generations is at stake. At the United States Supreme Court level, you know, we have 3 justices who have been taking a position to criticize the majority over and over again. But in this very important climate case, a very strong word was used by Justice Kagan to describe the position of the majority on their climate decision. And she called it frightening. She says, "I cannot think of many things more frightening." So atrocity law is being committed by the federal courts of the United States. West Virginia versus EPA is the case where Justice Kagan said that the analysis was frightening, and essentially the majority found that the Environmental Protection Agency really can't regulate greenhouse gas emissions because there wasn't a specific delegation when the EPA was created to protect the water and the air of the United States, which is a facetious proposition that's been unconvincing to courts throughout the world, and certainly was not convincing to the Hawaii Supreme Court, where we rejected that analysis. And the Juliana case, the reversal of the Juliana case I just covered, is a case that essentially said, yes, there may be an existential threat, but young people or the citizens of the United States should not have access to the courts because the remedies are too complicated. Okay, the atrocity law and the way in which the law is being perceived by young people is being changed in a direction that is certainly problematic. The 2 young people on the right, you may know about the fact they threw some soup on a painting and didn't damage the painting. They were put in prison for 2 years. You know, I sentenced as a criminal judge hundreds of people. And this is completely unjust and inconsistent with best practices to take 2 young people, never having committed a crime, and take their freedom away and put them in prison for 2 years, as opposed to putting them on probation. And another group of law-abiding citizens that held up traffic in London were put in prison for 5 years. So the use of the law in a way that creates injustice is certainly alive and well in the United States Supreme Court and in some courts that are mistreating young people that are climate activists. We have had this I enjoy explaining that you can have great hope for the future because, for example, in Hawaii, our legislature and our governor and our courts are all on the same page now about the fact that there's a right to a life-sustaining climate. In this case that was brought by young people, challenging the state for not having a climate protection plan for transportation, the governor agreed. And now the courts are monitoring the settlement agreement, and the plaintiffs and executive branch are working together. And as I noted, the legislature has declared a climate emergency. So there is hope. You know, governments can act on behalf, even at the executive and the legislative level, can act on behalf of future generations. This is the indigenous case that involved young people that was the subject of the historic settlement agreement that I mentioned. But this is the most important case in the United States. It's now in Hawaii. I think it'd be legitimate to say it's the most important case in the world. And it will be a very entertaining story that I'll tell very briefly about what happened, because this is where the city and county of Honolulu sued the oil companies for fraud, basically saying they misrepresented their product when they said their petroleum products would not cause climate change or global warming. Well, when the case was filed in Hawaii, there was a motion to dismiss brought by the giants. You can see these are the biggest oil companies in the world being sued in the court, and they're being sued for fraud. So they went to the trial court and then to the Supreme Court of Hawaii and tried to get the case dismissed, and the court said, no, it's just a state claim. Well, then it got particularly interesting because the President of the United States came to Hawaii to stop these cases. And essentially, technically what happened is when the Hawaii Supreme Court found that the case could proceed, and the giants went to the United States Supreme Court to ask the United States Supreme Court to reverse Hawaii's Supreme Court, reverse Hawaii's Supreme Court and say that states should not be able, the Hawaii state court should not be able to bring a fraud case against the oil companies. The Supreme Court of the United States eventually decided that they could not violate precedent to that extent and take the case and reverse the state court's decision on a state law claim. But then the giants went to those states with attorney generals that supported Donald Trump, and they all went to the president and they asked the president to file a lawsuit on behalf of the United States, file a lawsuit in federal court to stop the state of Hawaii from bringing the fraud case. And sure enough, he did. The president of the United States ordered the attorney general to bring a case, and the attorney general of the United States has now filed a case against the state of Hawaii to stop the state of Hawaii from bringing a fraud case, bringing any climate case against the giants. This is a completely frivolous case that I have no doubt will eventually be dismissed, but it will give you an idea of the atrocity law that's being committed in the United States by the federal courts and the federal government. Anyways, this is a New York Times article that described this remarkable violation of the rule of law and abuse of the rule of law by the President of the United States when the President of the United States sued Hawaii to prevent Hawaii from bringing any legal action against the giants. And to conclude, I think we're all aware that now at an international level, we have great hope. This is the most important climate case to be decided by a court. You know, the India Supreme Court in the Ranjit case have found that there is a constitutional right to a stable climate. Same thing has happened in South Korea. The court has made a similar determination. The International Court of Justice in July, I think we're all aware of the fact that they enshrined this right to a clean and healthy environment in the context of climate change and said that there is a duty, and they also focused on 1.5 degrees, but said there's a duty on the part of governments to protect this right. So what's the solution? Pretty straightforward. We just need a climate protection plan that explains how we're going to reduce greenhouse gas emissions. In other words, what do we do? How much do we depend on saving the rainforest? How much does the plan require alternative energy for transportation? How much does the plan require using geoengineering to refreeze the poles? But in any case, the role of the courts in developing this climate protection plan is something that is being mandated more and more by the lawsuits that are being brought by mothers and children around the world to protect future generations. So aloha from Hawaii. And here again is another picture to encourage you to come and visit. You know, we're small. We can't survive. We don't have much of a chance in this climate emergency on our own. So we depend on places like Brazil and India. And you would be very well received and be considered to be extremely important to our state if we can convince you in the audience from Brazil to come visit us. But thank you for the privilege of being able to address you, and aloha.
Thank you, Dr. Michael, for your invaluable thoughts here in the speech. So I would like to give the floor to Professor Katrina Q from Elisabeth Haub School of Law at Pacer University. Professor, you have the floor right now.
Thank you so much. Greetings and welcome from the Elisabeth Haub School of Law at PACE. I'd like to thank, in particular, our wonderful PACE partners in Brazil, FGU Law and Silveira and Athias. Thank you so much for helping to make this happen. And I'd like to pick up by building on Dr. Bentis's comments about the structural processes that are necessary to implement climate law, and also where Justice Wilson left his remarks by talking about some of the recent judicial developments, including the International Court of Justice issuing an advisory opinion defining the duties of states or clarifying the duties of states with respect to climate change. And, you know, one of the motivating forces behind holding this conference was that the ICJ advisory opinion, which came down and outlined very clearly why states have a legal duty under international law to take strong climate action, that was issued by the ICJ after the plans for this conference of parties in Belém had already been put together. And there was a concern that how do we make sure that this conference of the parties incorporates the ICJ decision and starts to think in a real way about how to implement it. And I was struck yesterday during the conference in terms of thinking about how do we implement the advisory opinion, about the contributions of our students and youth to climate policy, which Justice Wilson has been talking about. And to give everyone some background, I will tell you, I do not believe that we would have an advisory opinion from the International Court of Justice if it weren't for our youth and students. And I see that Professor Foreman will be speaking after me. I know Justice Wilson was involved. In my second year at PACE, I was part of a mobilization effort by students around the world, led by Pacific Island students fighting climate change, where students came together. They held legal briefings. They got petition signatures. They submitted letters to the permanent representatives to the United Nations. I think I was with Professor Foreman doing this with them to help some, and to be clear, we were supporting them. This was their effort. Tony Aposa and others helped to inspire them. But the idea was, their goal and their idea was, we would like to persuade the United Nations to ask the highest court in the world to clarify what are the legal duties of states with respect to climate change. And I have to remind everyone that yesterday we heard Professor Christina Voigt, who is one of the lead negotiators of the Paris Agreement. She was remarking on the important role of youth in convincing the UN to request the advisory opinion. And to quote her, and I wrote it down because I thought it was so important. She said that the youth role in getting that advisory opinion was, quote, unparalleled in the history of international courts. And she then exhorted us all to start thinking immediately about how do we implement the clear legal obligations identified in the ICJ decision through the structural processes that Dr. Bentis referenced and others. And I'll flag that here again, the youth and the students are leading the way. So just a few short weeks ago, a delegation of Pace Law students went to the World Conservation Congress held in Abu Dhabi. And what did they do? They proposed an emergency motion saying, hey, we have this, an emergency resolution saying we have this advisory opinion from the International Court of Justice. And they successfully advocated for the IUCN to adopt Resolution 141, which requests that the Director General of ICUN study all relevant legal instruments to think about implementation of the advisory opinion and calls upon IUCN members to take all appropriate measures to respect and implement the obligations set out in that advisory opinion. And yesterday and throughout this conference, we have included youth commentators in each panel. And what we've heard them say time and again is the emperor has no clothes. You're not doing enough. So yesterday we heard from recent PACE LLM graduate Maria Lambert, who began her remarks with a very plaintive and common sense plea, I want to be able to breathe. And she commented that there is no longer room for symbolic support and fence sitters with respect to climate change if we are going to prevent harm across generations and respect intergenerational equity. So here at Pace Law, I think we're very aware that probably the single best way that we can support the development of climate policy is by equipping the next generation with legal training and providing them with the context and support to lean into these issues. We look forward to continuing to do that. And I thank all of you for being part of this conference today to help us advance climate policy and think about implementing the advisory opinion of the International Court of Justice. Thank you so much.
Thank you, Dr. Katrina, Professor Katrina from Pace University. Dr. Savio, do you have the floor right now from Belém? Thank you for being with us today. So you have the floor right now.
Olá, bom dia, good morning, good afternoon, good night, wherever you are. First, I have to say that English is not my first language, so I write a few words for this moment. Ladies and gentlemen, distinguished guests, colleagues, and my dear friends, it's an honor to join you today on behalf of the Brazilian Bar Association, Para section, in this important conference connected to COP30. I bring warm greetings for an institution that brings together 30,000 professionals deeply committed to justice. As we meet here, the world faces one of the greatest challenges of our time, the acceleration impacts of climate change. Although global warming is by definition a global problem, its consequences are profoundly local. The Amazon region knows that this truth more intensely than almost anywhere else on Earth. That is why legal profession, and especially the Amazon legal profession, has a unique responsibility in this moment. Lawyers are not only interpreters of the law, we are guardians of rights, mediators of conflicts, and builders of institutional solutions. Our role is essential in transforming ambitious environmental principles into actionable public policies and enforceable legal protections. In the Amazon, this role becomes even more crucial. Here, the law is not an abstract concept. It's a living instrument that shapes the relationship between people and territory, between economy and ecology, between development and sustainability. Amazon lawyers stand at the front line where environmental norms must be applied in a context of cultural diversity, a geographic complexity, and deep social inequalities. We understand the forest is not as an idea, but as a lived reality. For this reason, global climate action must always be informed by local realities. It requires listening to those who live in the regions most affected by climate change and by the policies designed to confront it. It requires dialogue, action, and mutual understanding across borders and disciplines. This event and COP30 itself represents exactly this spirit, a true platform for international cooperation and shared learning. By bringing together researchers, practitioners, policymakers, and representatives of civil society, we create the conditions needed to design climate strategies that are equitable, legitimate, and sustainable. As president of OAB Pará, I reaffirm our institution's firm commitment to strengthen this vital action. In recent years, we have undertaken concrete initiatives to prepare the legal community for the challenge of climate governance. We have promoted broad climate law literacy across the profession through numerous courses, seminars, and academic events. We have closely monitored state-level climate policy through our thematic commissions, with particular attention to their impact in the legal profession and in the most vulnerable populations of our regions. And we have created, and I'm very proud about this, the Observatory of Climate Finance, an initiative designed to enhance legal certainty and institutional integrity in the flow of climate-related resources. Let me conclude with a reminder of something fundamental. The law has immense power to transform. When guided by science, by ethics, and by genuine commitment to human dignity, it becomes one of the most powerful tools we have to confront the climate crisis. And when legal professionals across the world join forces, we strengthen the fundamentals of more sustainable future. Thank you very much, and I wish an excellent conference for everybody.
Thank you, Dr. Savio, and thank you all the panelists to welcome the second day of this event. It's a huge pleasure to have the second day of this conference. More than 3 cities are connected right now. We are connected with the world by Zoom and YouTube, FGV channel. So we have all the conference here. And today we will have panels discussing climate finance, corporate, and the importance of courts and judges in the climate agenda and environmental law. So please stay with us on YouTube and Belém, New York, and here in Rio. Thank you, everyone. I would like to start the first panel of the day, of the second day of the conference, the role of the judiciary in the climate agenda. I would like to say thank you, Professor James May from Washburn University School of Law, and Professor Luke Larverson from European Union for Judge for Environment, Dr. Vinicius Bernardo from Brazil Association of Members of the Public Ministry of the Environment, ABRAMPA, Dr. Júlio Borges in Belém, Attorney General's Office, and Dr. Fernanda Tanuri from BMA Law Firm. Dr. James May, welcome, and the floor is yours. Thank you to accept our invitation to moderate this panel.
Well, bon dia, everybody. It's great to be a part of this conversation. Thank you for inviting me to moderate what looks to be, as we've just heard from Justice Wilson's remarks and from Professor Q in particular, to be the place to look for hope, and that's courts. And so this panel will focus on the role of the judiciary in addressing the climate crisis. So we're running a little bit behind time. So I think what we'll do is we'll just start right in and we'll walk through the panelists. Let me check with the conference organizers about 2 people. I'm just not sure if they're in the room there. Is Julio Borges and Fernanda Tanuri, are they in the room or are they on Zoom? Okay, well, I haven't heard anything, so I think what we need to do again, because of time, is to start on in. So let me introduce my friend, Judge and Professor Luc Laverson from the European Union Forum for Judges for the Environment, and also the Constitutional Court of Belgium. Professor Laverson, the floor is yours. Thank you.
So thank you very much. Good morning, good night, good afternoon. In my intervention, I will in the first place update quickly on climate jurisprudence in Europe, leaving corporate climate litigation aside, as this will be discussed in the next panel. And then I will focus on climate adaptation and the role of the judiciary. First, for climate adjudication, it was crucial to see if the European Court of Human Rights would endorse or not the human rights approach taken by the Dutch Supreme Court and other courts, such as the Court of Appeal here in Brussels. Meanwhile, we have the answer. The Grand Chamber of the European Court of Human Rights has nearly unanimously delivered last year, 9th of April, 3 judgments. Because the court judged that the particular characteristics of climate change did not justify to depart from the rules on jurisdiction, namely prior exhaustion of national remedies and victim status for individual persons, the 2 cases have been declared inadmissible. But the court judged the merits of one case, the case of the so-called Klimasignorinen against Switzerland. With reference to the Aarhus Convention, that's the UNESCO Convention on Access to Information, Public Participation and Justice in Environmental Matters, and national jurisprudence, the court is recognizing standing for associations under certain conditions in climate matters. This minimum standard on standing has been confirmed recently, 28th of October, by the European Court of Human Rights in Greenpeace Nordic case, and has already had an influence in countries where stricter standing requirements in climate litigation have been applied before. In January this year, the Supreme Administrative Court of Finland ruled in the second Finnish climate case. This time it reviewed the appeal on its merits, referring to Klimasignorinen to support expanded access to justice. However, the court ultimately dismissed the appeal, deferring to the government's assurances that additional climate policies were in preparations, and ruled that it was premature to evaluate the alignment of such policies with legal obligations. The Swedish Supreme Court threw out a class action lawsuit in February this year, but at the same time said if the case was framed otherwise and introduced by an association, like in the Klimasignorinen case, the outcome would be different. As the merits are concerned, the Klimasignorinen judgment provides certainty after the Dutch and Belgian judges had already laid the foundations for it, namely that insufficient climate policies can violate human rights. The obligation imposed on the state by Article 8 of the European Convention of Human Rights, that's the right to the protection of private and family life, is to fulfill its part in mitigating climate change in order to ensure the right of individuals to benefit from effective protection by state authorities against serious negative effects on their life, health, well-being, and quality of life resulting from the adverse consequences and risks linked to climate change. Effective respect for the rights protected by Article 8 requires each state to take measures to significantly and progressively reduce its greenhouse gas emission levels, with a view to achieving net neutrality in principle within the next 3 decades. In this regard, for the measures to be effective, public authorities are required to act in a timely, appropriate, and consistent manner. While this judgment is certainly said to have international impact, it's about all of great importance for national courts in the member states of the Council of Europe, because the court said in its judgment, and I quote, "The court considers it essential to emphasize the key role which domestic courts have played and will play in climate change litigation. The facts reflected in the case law adopted to date in certain Council of Europe member states, highlighting the importance of access to justice in this field. Furthermore, given the principles of shared responsibility and subsidiarity, it falls primarily to national authorities, including the courts, to ensure that the Convention's obligations are observed." And I think this is a very strong message to all 46 national judiciaries within the Council of Europe. The message has been already picked up by the Constitutional Court of Hungary, that with a judgment of the 3rd of June this year, declared the Hungarian Climate Act unconstitutional and ordered the legislature to come with a new one at the latest June 30 of June next year, covering the 3 priority areas of the fight against climate change: mitigation, adaptation, and resilience. Besides human rights-based litigation, there is also growing climate litigation on the basis of climate and environmental law, in particular concerning projects with a noticeable impact on global warming. Just 2 examples. 2 environmental NGOs challenged 3 administrative decisions whereby the Norwegian Energy Ministry approved the plan for the development and operation of 3 oil and gas fields in the North Sea. The 3 fields in question have been subject to impact assessments by the companies that are operators and licensees for the fields. However, these impact assessments did not include combustion or Scope 3 emissions from the oil and gas produced. In 2024, the Oslo District Court concluded that all 3 decisions were unlawful, because there is a legal requirement that Scope 3 emissions must be subject to an impact assessment pursuant to the applicable regulation. The case has been appealed, and the Court of Appeal has asked an advisory opinion of the EFTA Court of Justice in Luxembourg, the sister court of the Court of Justice of the European Union, on the interpretation of the Environmental Impact Assessment Directive. And in a judgment of May this year, the court held indeed that Scope 3 emissions should in that case be part of the assessment. And a similar similar judgment was taken by the Court of Session in Scotland, that is the highest Supreme Civil Court of Scotland. And meanwhile, the European Court of Human Rights in its judgment of 28th of October 2025, in the case of Greenpeace Nordic and others versus Norway, underlined in particular that when making a decision in the context of the environment on climate change, in particular on large fossil fuel projects, the state has to carry out an adequate, timely, and comprehensive environmental impact assessment in good faith and based on the best available science. An impact assessment must include, at a minimum, a quantification of greenhouse gas emissions anticipated to be produced, including the combustion of emissions both within the country and abroad. Moreover, at the level of the public authorities, there must be an assessment of whether the activity is compatible with their obligations under national and international law to take effective measures against the adverse effects on climate change. Lastly, informed public consultation must take place at a time when all options are still open and when pollution can realistically be prevented at source. Let's turn now to climate adaptation. Domestic jurisprudence on the matter is in evolution. While the Pakistan court from the outset in the Asghar Leghari case dating back to 2015 derived a positive duty to formulate and implement a coherent and effective adaptation policy from the right to life and dignity of the Constitution of Pakistan. In the European Urgenda and Klimaatzaak cases, the focus was nearly exclusively on mitigations, the courts rejecting government defense that adaptation measures could offset the less than requested mitigation ambition. Meanwhile, in Europe, the German and the Hungarian constitutional courts have done the same. Nearly all international, global or regional human rights bodies and courts have meanwhile dealt with the question. Domestic and international binding and advisory jurisprudence has gradually derived from fundamental rights contained in national constitutions and international human rights law, read in conjunction with international climate law and customary law, a positive obligation for states and governments to develop and implement effective adaptation policies, complementing their mitigation policies under an enhanced or stringent standard of due diligence. States are thus required to adopt, regularly update, and implement national adaptation plans, consistent with the United Nations Framework Convention on Climate Change, the Paris Agreement, and as European Union member states are concerned with the European Union climate legislation. Adaptation must be guided by the best available science, respect for procedural rights, the principles of progressivity and precaution, and non-discrimination. It may thus be expected that in the international and European climate policy and law machinery, if that machinery is not able to turn the tide shortly, some actors might turn to the judiciary to have the plans and policies in force reviewed. The opinions of the International Court of Justice and the Inter-American Court of Human Rights seem to indicate that judicial review of adaptation policies should not testify of a considerable degree of deference towards government, given the strict or enhanced due diligence to be applied and the other qualitative criteria put forward. In this respect, and to end with, I would like to draw your attention to a very recent judgment of the Court of First Instance here in Brussels. In its judgment delivered on 29 of October 2025, in the We Are Nature Brussels case, the court found that the Brussels capital region failed in its duty of care and precaution regarding climate change by not adapting its land use planning to its obligation to increase its territory's capacity to capture carbon, as well as its obligation to adapt the city to combat the risks of flooding and urban heat islands. The court held that by continuing to authorize real estate projects on undeveloped sites larger than half hectares based on regulations deemed obsolete because they were adopted before the awareness of climate issues became widespread, the region committed a fault in the sense of the Belgian Civil Code. And to limit the damage to the residents who brought the case, alongside two environmental NGOs, the court has ordered a moratorium on the urbanization and paving of sites larger than 1.5 hectares until the government finalizes the revision of the regional land use plan to integrate adaptation and carbon sequestration into land use planning, and this moratorium until December next year. It seems the first time that the court has ordered a moratorium on urbanization on the scale of an entire city and region. The judgment is enforceable, meaning it remains fully effective even if the government would decide to appeal the judgment. So with that, I think adaptation policies will come to more and more to the judiciary, and I think we will see further developments in the future. I thank you for your attention.
Thank you so much, Professor Laverson. Next, we have Vinicius Lambertia Bernardo, and please forgive me for mispronunciation with your remarks. The floor is yours. Thank you.
Hello, everyone. Good morning, everyone. I congratulate, first of all, the organizers of the event, and I thank you so much for the opportunity to represent the Brazilian Association of Environmental Prosecutors here. I also congratulate Dr. Rômulo Sampaio, a brilliant professor, lawyer, and longtime collaborator of Abrampa, having already participated in our Congress and the events. Dear Rômulo, we miss you here in Abrampa, so you should come visit us soon. It will be a pleasure to have you again with us. I apologize, everyone, but as I haven't given a lecture in English for quite some time, I will continue my speech in Portuguese. So, bom dia a todos e todas.
So good morning, everyone. It's a pleasure to be here representing Abrampa in this excellent event. I congratulate PACE Law School, IUCN, the World Commission on Environmental Law, and FGV Law School. I'm going to speak to you about the climate and the agenda of the judiciary power and approach some of the judicial decisions that were handed out by the first and the second courts that are advancing the climate agenda in the judiciary power here. The first point to be approached here is that the climate litigation and the advance of the judiciary in this topic, it starts from the omission of the main sectors, the public and private sectors, in take effective measures of adaptation and mitigation. I'll bring, for example, the annual report called the World Annual Outlook, published by the International Energy Agency yesterday, November 12th. According to the agency, the planet Earth is going to warm the double of the Paris goal, and we are going to experience an increase of 3 degrees by 2100 if we keep the same mitigation and adaptation policies. In the national context, I highlight the report of the Climate Observatory, the update on the inventories of greenhouse gases emissions made in the beginning of November. In the national territory, we experienced in 2024 a reduction of the emissions, especially because of the decline in the deforestation rates. However, we had an increase of emission regarding to wildfires, and considering the total of emissions, Brazil is not in the trajectory to meet its contribution nationally determined the NDCs according to was agreed upon with the international community in the Paris Agreement. Because of this insufficiency of these measures, the judiciary advances to determine concrete measures. In the national plan, I want to go over the legal fundamentals, the main legal fundamentals that endorse the management of legal lawsuits for the provisions related to adaptation and mitigation. First and most important, and it's important to highlight because we are in an event with an international community, Brazil has in its constitution the Article 225 that established the fundamental rights to an ecologically balanced environment. So we have a rule in the Constitution that guarantees the rights to an ecologically balanced environment as a fundamental right. And the stable climate environment is not dissociated to the balanced environment. So litigate in the climate area is to litigate in the defense of fundamental rights, not only of the Article 225, as well as many other fundamental rights guaranteed in our Constitution that are put at risk by the global warming and climate change effects, and the right to private property, the right to housing, the right to health and life, and food security, potable water, and many other fundamental rights guaranteed constitutionally that are put at risk because of the climate change and global warming. Not only the domestic Constitution, we are signatories of international treaties as the Paris Agreement, and we highlight here the duty to control and the conventionalities of our courts. We have infraconstitutional legislation that guarantees the stable climate system. As an example, our national policy on climate change, and the recent Law 14904 of 2024 that deals with the adaptation plans of the federative entities. Based on all this legal framework, I highlight the first decision of the Supreme Court that was important to consolidate the thesis of the duty of the states to guarantee the stable climate system. That was our DPF 708, and I will quote part of the decision that is important. According to the Supreme Court, the executive power has the constitutional duty to make possible and allocate annually the climate fund resources for the mitigation purposes of climate change. Remembering the context of this action, for those who don't know, it was a constitutional jurisdiction action trying to force the federal government to use the budget that is in the climate fund with the purpose has to be reverted to adaptation and mitigation policies. In our context, we have the constitutional duty of the Union of the Representatives to guarantee the right to a stable climate. And we have a fertile environment for climate litigation, while our public and private entities do not comply their role in draft mitigation and adaptation measures. Besides this legal framework and the Supreme Court decision, recently we edited many announcements on the Federal Justice Council related to the climate litigation to make them viable. It's important to mention these announcements because the organizers were not less than the Supreme Court Justices Herman Benjamin, Luiz Felipe Salomão, and Paulo Sérgio Domingues. They participated in this construction of this legal framework, many federal judges, and it was an event that counts on the institutional support of the Magistrate Association and the School of Magistrates of Rio. That shows that more and more the judiciary power is permeated not only in the upper and the lower instances to the climate arguments. In this broad legal framework, I'll bring some data about the overview of climate litigation in 2025 in Brazil. This is a report drafted by the Interdisciplinary Core of the environment of the Catholic University here in Rio. According to this data, we have today 332 climate actions mapped by August of 2025, and Brazil leads the Global South and became the second country in the world with the biggest number of climate litigation cases, only behind United States. The main actions approach in these climate litigation cases are referring to mitigation, civil responsibility for climate damage, and in climate risk assessment. And besides that, the main sector of the greenhouse gas emissions that is being the object of these sanctions is the land use change and the use of forests because of the prominence of the emissions resulting from deforestation and illegal wildfires in our territory. And I'm going to approach a few specific topics that deserve our attention in the judiciary power, and we have positive outcomes. The first is the climate damage, the quantification of the climate damage. We assume that the illegal emissions of greenhouse gases resulting from wildfires and deforestations need to be reimbursed to the Brazilian community. According to the overview of climate litigation made by the Catholic University, last year and this year alone, we had 195 new cases related to the fourth phase of the Protection to Amazon projects. That is a project from the prosecutor's office where we file lawsuits of civil liabilities for climate damage, where we quantify in this the quantification of the climate damage. And the quantification of that results from a resolution of the National Council of Justice, a resolution 433, that established a protocol of trials of civil lawsuits in managing the environment, and the Article 14th determines that in the conviction for environmental damage, the magistrate has to consider the impact of this damage in the global climate change. In Brazil, we already have methodologies to quantify this climate damage, and actually we have two methodologies that are being experienced in civil lawsuits. The Federal Prosecutor's Office is using the EPAN, the Amazon Research Institution, that is contained in this initiative of the carbon calculator of the Institute. They developed a carbon calculator mechanisms that is applied to all the Brazilian biomes. When you upload the deforested area, you can obtain the cost of carbon of that deforestation. And this cost has been incorporated in civil lawsuits, especially in the Federal Prosecutor's Office, and the ABRAMPA edited a technical norm along with the EPAN, the Institute, recommending the use of this carbon calculator where the ton of carbon costs $5 to be used in the civil lawsuits for climate damage. There is another methodology. This methodology was used in some of the actions of the Attorney General's office that is doing an excellent work in this area of civil liabilities regarding climate change, where we can quantify the cost of carbon where the ton of carbon has a higher cost. And both of these cases, the public civil actions using the methodology of the institutes and the methodology of the OECD has been well received by the judiciary power with these provisions. Another issue of environmental licensing, another field that is the object of civil lawsuits, is the environmental licensing. The assumption is that the greenhouse gases emission is a diverse environmental impact, and it needs to be assessed in the environmental licensing of developments. The main challenge here is that the environmental bodies can publish instructions and guidelines detailed to establish the terms of reference so the entrepreneurs can know exactly how to account for the greenhouse gas emissions, how to mitigate them, and how to offset them. While the environmental bodies do not undertake this task, many lawsuits are being held in Brazil. We have 17 climate cases that are active on environmental licensing. The most famous one is the Port of Santarém. the lawsuits related to the thermal power plants in Rio Grande do Sul, and lawsuits moved in the municipality of Candiota in Rio Grande do Sul. All of these actions are being procedural, and so the licensing can be suspended or the license can be revoked until the climate impact of these developments can be properly addressed by the environmental bodies. Another field of action of the judiciary power are the structuring demands and the fights against the omissions of the public power in the implementation of public policies. I want to remind you that the Supreme Court has the topic 698. The 698 says that it disciplines the intervention of the judiciary power in issues related to public policies. According to this topic, the judicial decision as a rule, instead of determining specific actions, they have to determine the purposes to be presented and adequate plans to reach these results. This is a good way out to equalize the duty to implement measures to guarantee fundamental rights and the principle of separation of powers. And the judiciary that does not have a constitutional mandate and does not have the constitutional capacity to draft plans with concrete mitigation and adaptation policies is restricted to direct a general provision for this general plan to be elaborated by the public power and the governments, and then the governments through a participatory process with the civil society and the business sector can determine the necessary measures to reach that result. And in this context, we had actions that the DPF 760 and 54 that the court decided that we have to provide effective measures to protect the Amazon, and the 63 that the court recognized the omission of the National Congress in approving a specific law to protect the Pantanal biome. And we have a context here where the judiciary adopts the concrete measures to guarantee the effectiveness of relevant policies for the climate stability. I'm getting to my end here because I think I ran out of time, and we already have cases of civil lawsuits related to adaptation, and I have here the Public Prosecutor's Office against the state of Pará and the municipality of Maracanã, where we filed a lawsuit to guarantee emergency actions to contain coastal erosion that was threatening the existing of a traditional community that in the reserves of Maracanã. This civil lawsuit was judicialized after 6 years of decisions that tried to guarantee adaptation measures to reduce the vulnerabilities and increment the resilience of traditional communities. With that, I get to my final remarks, saying that we have a big field to increase the climate litigation in Brazil. There are positive points of climate litigation to strengthen the effectiveness of public policies that are not being implemented in its highest potential. We have managed to insert the climate variables in the risk assessment. We guaranteed the fundamental rights and the accountability for damage in the climate area. And it seems that an important measure is to increase the areas specialized in environmental law. Right now, the federal government is elaborating the climate plan to draft adaptation and mitigation plans. The ideal is to advance in this agenda in the executive, legislative power with the active participation of civil society. Now, in case the climate plan does not show up to the challenge that Brazil needs to face, and then we are going to experience an increase of civil lawsuits of climate litigation in Brazil. And it seems that this is going to continue by the increase of systemic actions against big corporations, especially in the fossil fuels and agriculture, an increase of lawsuits by civil liability of the government for omission in case of big social environmental disasters, and greenwashing. With that, I apologize because I ran out of my time, and I stop here, and I wish you a great event.
Obrigado. Thank you so much, Vinicius. Terrific remarks from the Public Prosecution Office for the state of Rio about events in Brazil concerning climate litigation. Next, we have Julio Borges, and again, pardon me if I didn't pronounce it correctly, but the floor is yours. Thank you.
Thank you, Professor. So first of all, thank you to Pace Law, to FGV Law School, and to all the organizers for this, for the invitation for this event. It's an honor to talk about climate change and environmental protection in such a special moment as COP30 takes place in the Amazon region. So just for a brief note about my professional background, I've been working with the Attorney General Office in the Brazil's federal government, which is called the Advocacia Geral da União in Portuguese, for the past 12 years, dealing with legal advice to senior authorities at IBAMA, which is our largest environmental agency, and at the Ministry of Environment, but also working with enforcement strategies before courts to reduce illegal deforestation in the Amazon rainforest. However, all my remarks here are personal, and I don't talk on behalf of the Attorney General Office here. For the past 30 years, Brazil's environmental law and policy has used what's called command and control legal strategy for the environmental protection in the Amazon rainforest, which stores the equivalent of 5 years of global carbon emissions. This strategy has its advantages and disadvantages. I'm going to use my time today to give a critical review of that strategy focused on two main issues. The first issue with the strategy is that business players are only involved with environmental agencies, mostly in adversarial relationships. That's only brought into the picture as recipients of our environmental agencies' fines and as defendants in our legal actions. The second issue with the strategy is that these business players we deal with are very often the local producers, such as farmers and ranchers, and the big industry, which is to say the bigger producers and distributors who aren't necessarily based on the Amazon themselves, but rely on a supply chain that involves the Amazon region, very often are not touched by environmental agency actions. And it doesn't happen by chance. It's just hard to create legal proof that demonstrate the causal relationship between big industry trade practices and environmental violations. So a minute ago, I mentioned the adversarial relationship between environmental agencies and the private sector. In fact, last year, for example, IBAMA issued 16,000 fines in just 1 year. Think about the resource, the manpower, and the hours which go into issuing these fines, those fines. And issuing a fine is not the end of it. It's just the beginning of what is often a long process, as the fined party often takes the case to court to challenge IBAMA's action. We in the executive branch rely on the judicial branch to enforce the fines, seizures, and embargoes issued by IBAMA. Embargoes, by the way, is a very powerful administrative act that severely limits the use of a given private property. Indeed, most environmental fines are disputed by the recipients, bringing IBAMA back into court, as I said before. Further, when the fines aren't paid, and most of them are not paid, IBAMA needs to go to court again to get these fines enforced, sometimes adjusting for inflation due to how many years have passed. Environmental agencies also count on courts to impose civil penalties, which allow the state to recover damage to the environment. Indeed, the Attorney General sues hundreds of farmers and ranchers every year for environmental violations in the Amazon rainforest. In the past 4 years, for instance, the Attorney General Office charged more than $1 billion in civil penalties in the Amazon rainforest. Not surprisingly, IBAMA is one of the top 10 litigants in our federal courts. That brings us to the second issue with Brazil's strategy, the part about loopholes. Out of the thousands of fines in the Amazon rainforest, about 95% have been directed to small producers, farmers, and ranchers. On the other side, the big drivers of the industry, both on the production side and the consumer side, remain a blind spot for enforcement strategies for environmental law in the Amazon. Then it's hard to celebrate legal victories against the smaller fish when the big fish are still so visibly unaccountable for their supply chains. So what can we do about it? If we consider some practical methods and some elements from a different philosophy, things could work differently. If we had more engagement with the business players of the Amazon, especially the big industry players, we could work with them instead of just trading lawsuits and fines with them. If we make a framework which leads them and their suppliers, for instance, to comply with the law, we will reduce the harm to the environment and allow government resources to be used more efficiently. On the other side, business could save resources for themselves and enjoy the prestige of receiving certain, for example, sustainability recognition and certifications, which could be agreed on. So just to be clear, the command and control legal strategy used by the Brazilian environmental law and policy is and will remain essential, but it is still insufficient. In fact, this legal strategy to tackle illegal deforestation in the Amazon rainforest has seen mixed results over the past 30 years. The deforestation rates over the past 3 decades remain volatile, alternating times of strong reduction with periods of increased deforestation, always depending on economic and political circumstances. Without creating accountability for major players in industries whose supply chains rely on the Amazon rainforest, such as the beef industry, the logging industry, and the mining industry, we will continue to see environmental agencies and courts in Brazil overwhelmed by carrying alone most of the responsibilities for controlling deforestation in the Amazon. After all, beef, gold, and timber are commodities that come from economic activities that explore natural resources of the Amazon region. And to create accountability for crucial industries in the region, we could rely on collaborative governance ideas, which allows strategic partnerships between agencies and the private sector in order to work together around public interest goals such as protecting the environment. Unfortunately, I don't have enough time here to discuss about that theory and its implication for environmental law and policy in Brazil, but soon will be defending my doctoral dissertation at PACE about this theme and hopefully publishing it in a law review. I'm convinced that under special circumstances, such as those related to protecting nature in the Amazon rainforest, a highly important system for climate change and for protecting biodiversity, but also a place where several obscure economic networks and conflicting interests dispute the control of the region, environmental agencies and courts alone will be not able to address and completely halt deforestation in the long term. The adoption, for example, of nationwide programs for labeling products whose supply chains might impact the conservation of the rainforest could be, for instance, could be an example of an effective and efficient way for the purpose of creating due diligence for important markets in order to protect essential ecosystems such as the Amazon rainforest. So working together, environmental agencies and the industries could create an institutional environment to provide innovative solutions to tackle illegal deforestation on the Amazon. That partnership would benefit from increased expertise, shared experience, and research from both sides to tackle such a complex mission as halting deforestation in the Amazon rainforest. Thank you very much.
Thank you very much, Julio, from the Attorney General's office. Next, we have Fernanda Tanote, who's a partner with the BMA law firm in its Environment, Climate, and Mining division. Fernanda, the floor is yours. Thank you.
Obrigada. Obrigada, professor. Bom dia, boa tarde, boa noite.
Thank you so much, Professor. Good morning, good afternoon, good evening.
Eu vou falar em português.
I am going to speak in English because I'm a lot smarter in Portuguese and other languages. But talking about the judiciary and the climate agenda, I'd like to say that we have not only had an increase in climate litigation, but also the complexity of this discussion. And it's important to remember that we're not talking about pro-climate actions, but also actions that go against the climate agenda. And when we have this number of 342, it is also discussing actions against climate. But in a general way, what are the main three topics that we have here? That is damage, reparation, and adaptation to mitigation. And I'd like to focus on adaptation of mitigation a lot because of my background. I was a director of CETESB, and I was able to live that really in my day-to-day. That is how we try to sort of connect climate agenda and climate licensing and environmental licensing. And we have recently had that law approved and it will start operating next year. And one of the critics that we've had was to not have a good agenda in this legal framework. And looking at this panorama that we have now, we do not have a legal basis to do this attachment in the licensing, and it's a shame. But our national policies for climate change from 2009, it does not mention the word licensing, so it has no sort of connection with licensing. But on Article 6, when we're discussing the tools here, it says that we can use existing measures or to be created that will simulate process and technology for the adaptation and mitigation, and also talks about goals for the decrease of emission of greenhouse gas. And so I think it's really complicated to try to have this connection as a direct application. But in terms of the states here in São Paulo and Rio, it says that licensing should be in accordance with climate, in agreement with climate issues. And in Rio Grande do Sul, it says that licensing has to follow legal regulations because of the environment. But when we come back to the state of São Paulo, it says that the analysis of the emissions should be incorporated in environmental analysis, just like when we're talking about NOx, VOx, that would also be done in the environmental quality analysis when we're talking about greenhouse gas effect. Same thing when it comes to river pollution. And both in São Paulo and Rio de Janeiro, they demand the inventory presentation on scopes 1 and 2 for some types of businesses or in places that have a greater amount of emissions. And they do have to validate this methodology, and maybe even through an independent consultancy. And in the state of São Paulo, we already have the pathway to do this, but not in the federal sphere. And so how we do here is, I have seen in practice, not only for the reduction of emission, but also for adaptation mechanisms, when we're considering CETESB, that is the body here in São Paulo that oversees the environment, they already have robust infrastructure, especially when we're talking about sanitation and the licensing for big companies. They are already in accordance to these adaptations and mitigation measurements. And what are the risks here? We sort of lose our isonomy, because if we have a general regulation and uniform regulation, the one that did it first will dictate the rules. So when we analyze Juma's data, we have 341 legal actions that were and will be analyzed by the federal government, and especially against companies, and not in a broad way. So when you demand mechanisms for reduction or even reparation for climate damage without a structured normative base, you end up creating some differences. So when we get Juma's data, what are the main 10 norms that are mentioned here? It talks about the fundamental right to a balanced, taken care of environment, the national policies of the environments that are from 1981, the Paris Agreement that was internalized by that decree, Article 160 of the Federal Constitution, and the environment here was mentioned in 2003. It talks about the defense of the environment as something that is the base of our Constitution. We also have the dignity of our human individuals in our fifth article. And then in 7th, we have climate change mentioned. In 9th, the United Nations talking about the climate change. And in 10th, we have Convention number 9. So these norms are very broad, and they do not discuss any obligations, and that might be complicated. Just like I mentioned, 86% of the cases that we have deal with the subject in a systematic way. Now, when we talk about international international cases, in 2024, we saw a total of 226 actions that, and I apologize, I'm having technical issues with her microphone. Oh, okay, sorry. And in Brazil, we have four cases that were, oh, thank you. It's better, yes. Yes. To have a protocol that was created by the National Council of Justice to judge environmental lawsuits in case of deforestation and fires. And it says that the policies for the environment, and the 14th article, it says that we have to consider the impact of environmental damage in a global sphere. So how will a judge value an impact of an environmental impact in a global sphere? So I think that to have this type of analysis, without getting into how this valuation is done, but we do need that type of document in a broader way. The second thing is climate washing, that according to the London School of Economics is the most used strategy by companies. And the last one is turn off the taps, that are the actions against pension funds. So is to stop funding businesses that have a very heavy carbon footprint. And when we're talking about failing in adaptation to mitigation that do not consider the climate risks in their businesses. And then last year, we've had in the Ministry of Transportation this decree that says that 1% of the gross income of these roads will be used for mitigation and sustainability measures. So we have a long way ahead of us, but we can already see that in the judiciary to provide with help. And then just to close up, I know that we're a little late, and my dear friend Celso Pereira is in Rio, but recently we've had a decision from the judiciary in Rio Grande do Sul. They have determined that thermoelectrical mills that are licensed by IBAMA and coal mining that are licensed by COPAMA have to be assessed. In other states, we do not have determination, and other, businesses that might have such a heavy carbon footprint just like they do will not have that component. So even when we're talking about a fiscal war so that companies can work in a certain municipality or a certain state, this can end up becoming an environmental war or climate war inside our country, and where each state can make their own decisions. So we need a national regulation so that will have a uniform decision for these analysis, for these decisions. They would have to have a validated methodology for that. IBAMA is prepared for that. They have recently said that they will issue a legal guideline, an environmental and technical guideline to show how these analyses have to be done. So really, we have to understand how that is going to be done. So I wanted to bring a few reflections, especially as a lawyer here, to show you the complexity that is to have this topic in our judiciary without having the agencies all prepared for such a hard work job.
Thank you so much. And then we have a student commentator, Dr. Amir Salim, who has an SJD and is associated with the Elisabeth Haub School of Law at Pace University. Dr. Salim, the floor is yours. Thank you.
Thank you, Professor May, and good morning, everyone. First of all, let me say that it's a privilege for me to join this distinguished panel to reflect on the role of judiciary in advancing the climate agenda. I have been listening to many panelists talk about importance of public participation and EIA. I wanted to discuss the importance of both these concepts in environmental litigation, but because of the scarcity of time, I'll only limit myself to one comment. As you may already know, I'm from Pakistan, and Pakistanis court have developed a great progressive jurisprudence on every environmental issue. Judge Levrison has also mentioned Asghar Lagari case, but I want to mention a unique quasi-judicial approach that Pakistani courts use, which is called environmental judicial commissions, and what is their role in environmental protection. So to start with, I would like to talk about three key environmental key challenges to environmental litigations around the globe. The first challenge is that courts often lack special and technical expertise in environmental matters and may require assistance to decide the dispute. The second challenge is that some interested or affected environmental groups, members of the public, and stakeholders are sometimes unable to participate in the proceedings due to the high cost and lengthy process associated with environmental litigation. The third challenge is that sometimes the courts focus on legal, technical, and financial aspect of the case rather than prioritizing the environment as a fundamental right. And the outcome may not fully address the environmental concerns at the heart of the dispute. So to deal with these three challenges, the Pakistani courts have devised a system called environmental judicial commissions, which are appointed by the Supreme Court and the high courts using their powers under the constitution. And these are appointed in public interest litigation that involves the right to environment. And these commissions assist the judges in a highly technical or complex environmental disputes. So what happens is that the court appoints a chairperson, a secretary, and some other members based on their relevant expertise in the subject. And these members are chosen from the public, government agencies, NGOs, environmental lawyers and experts, university professors, and even media groups. So Pakistani courts have constituted more than 20 commissions on different subjects. And these commissions can be categorized into 6 categories. And there were two commissions on protection from the nuisance in residential area. There have been also 4 commissions for water preservation in different regions in Pakistan. There have also been 2 commissions on air pollution. There have also been a commission for protection from the land pollution. There has also been a commission for protection of endangered species called Hubara bustard. There have also been commissions for environmental management and to review environmental laws and policies of specific areas. And these commissions make recommendations to prevent the further destruction and degradation of the environment. So all these commissions have worked pro bono. They have only sought some logistic supports from the government authorities. These commissions have visited pollution sites. They have verified facts. They have conducted inquiries and investigations in environmental matters. And they have provided the technical and scientific advisory to the court. They have held the meetings of the stakeholders, experts, and government officials to arrive at a consensus for making recommendations to the court. And the most important thing is they have requested comments from the public. They have invited public to participate in their proceedings. And then they have also complied with those comments and suggestions received from the public. And after all this exercise, they have made appropriate recommendations to the court, which were all ordered to be implemented for environmental protection. And in some cases, the courts also appointed follow-up commissions or task force to implement and monitor applications of its recommendation. So so these commissions have played a significant role in developing and enforcing environmental laws in Pakistan. They have addressed and even resolved broader environmental issues concerning a project, a city, province or even the country within the shortest possible time. They have served, I'll say, a more fundamental role. They have proved themselves to be an effective remedy for enforcement of the right to environment and a unique strategy to resolve the environmental disputes. So like Pakistan, most countries have also similar provision in their laws that they have not been using to resolve complex environmental disputes. Lastly, I'll say that these commissions can have three key benefits to address the challenges of environmental litigation. These commissions can provide investigative, monitoring, scientific and technical advisory to the court. Secondly, they can conduct open meetings and discussions in an informal manner, and they can also organize hearings to ensure public participation in ongoing environmental disputes without the barriers of expensive and lengthy litigation. And they can also bring all those stakeholders and experts together under judicial oversight and then develop consensus and cooperation among those stakeholders for solution to environmental problems. So this Pakistan example shows us that a country with limited resources and a similar environmental problems can adopt these practices for resolution of complex environmental disputes and for protection of the environment. And I'll conclude by saying thank you.
Well, thank you very much, Dr. Salim, for those remarks. So I think we've heard a terrific overview of the ways that the judiciary can affect climate change and impact climate rights, starting with this morning, some remarks in a global context. And then, there are, as we've heard, this number of 3,000. There are 3,000 climate litigation cases all around the globe. And as we also heard from this panel, there are an increasing number from Brazil. And so the vanguard for climate change currently isn't necessarily the negotiators in Belém that are meeting today or this week or next. It isn't legislators in the United States. It isn't the United Nations, although everyone can play a part, right? It's judges, it's jurists who are willing to brave the cold, as they say, and issue courageous opinions applying rights, like Article 225 in Brazil, or Article 14 of the Pakistani Constitution that Dr. Salim just reminded us of. It takes judges to help confront the climate crisis. Judges are a necessary but not sufficient voice for climate action. And so with that, let me just conclude by thanking the panelists for those terrific interventions. And I will turn the program back over to the conference organizers. Let's thank the panel one final time. Thank you.
Professor Jim May, I would like to say thank you again for your moderation of this panel. So we are running up here with the panel. I would like to introduce the second panel of this day, the corporate climate action. I would like to welcome Professor Rômulo Sampaio of FGV Law to take seat here at Rio de Janeiro, and Dr. Tiago Moura from New Fields, Dr. Márcio Pereira, partner at BMA Law Firm, Dr. Alessandra Lehmann for co-chair in Climate Law and Governance Initiative, Dr. Fábio Flores, a special thank you for helping to organize this event in Belém, partner at Silveira Tias Law Firm in Belém, and Dr. João Irineu, Vice President of Stellantis. So, and I have the youth commentator from Elisabeth Haub School of Law on Zoom. Welcome, Karen Lowy. So, Professor Rômulo, take the stage here, please. You have the floor.
Thank you, Emmanuel. Thank you, my good friends in Belém, in New York, all of you that are watching from around the globe via YouTube or Zoom. I would like to welcome our panel. Emmanuel already introduced them. So we've heard earlier this morning about the role of the judiciary, and now it's time for us to hear how corporations are driving the path voluntarily so that the judiciary doesn't come after you, like we heard in the previous panel, right? And for that, I would like to start with Thiago Moura, good friend from Newfields, Brazil. Thiago Moura, you have the floor. Thank you.
Thank you, everybody. Good morning. First of all, it's a great pleasure to be here this morning with my good friend Romulo. Also meeting some old friends and getting to know some new friends. So looking forward to stay in touch and connecting and supporting more events like this. They're so critical for the future of our kids, in the future of humanity and the world and the planet. More than a speaker today, I'm here to learn with my colleagues that have a lot more knowledge about the specific subject than I do. I graduated in forestry engineering 20 years ago, and this whole discussion about climate change, global warming, has been discussed in universities since then. And we had different cycles over the years. So I've seen, all these discussions mutate over the years. Carbon sequestration, cap and trade, the Chicago stock market, the voluntary stock market, and anyways, many discussions have occurred over the years, and I think that the 2008 financial crisis really has impacted the progress in this arena, the climate change battle, I would say. So I will briefly discuss and bring some insights this morning under two different perspectives: the engineering, the forest engineering, natural resources conservation science, and also under the economics prospect, because I also study economics, and my master's was in game theory, and I think we can grab a lot of insights from game theory and applying in this matter. Regarding corporations, over the years, I've been working on many cases, some with Márcio, some with Romulo, and litigation regarding natural resource damage and pollution. And what I've seen over the last 20 years is that, there's a lot of uncertainty related to these disputes. So these conflicts, they really cause a lot of pain to companies, to the private sector. I understand that, private companies, they have to evolve, they have to adapt and implement state-of-the-art environmental practices. And as most of the companies I work with, they have been really working hard on that. But, it's challenging. It's challenging because you're dealing with a resource that's still being better understood, natural resources, soils, water, air, and etc. So I've seen a lot of reputational damage, impacting sales, impacting investors, long-term uncertainty for clients. One of my clients in the Northeast, they've installed a power plant, coal-generated power plant. Actually, not coal, natural gas power plant, 10, 15 years ago, and they're still disputing the licensing process in courts. So they've been operating for 10 years, and they're still discussing how they obtained the license. And emissions is one of the topics that's being argued in court. Some other clients also, they had to deal with emissions lawsuits. So how to better control their emissions, how to improve on that arena, and also they got involved in the greenhouse gas discussion. So in Brazil, we don't really have standards that companies and industries have to comply in order to fulfill their license regarding greenhouse gas emissions. But we do have standards for sulfur, for dust, for particles, PM5, PM2.5, and etc. So I've seen a lot of times also these technical standards that were developed for human health protection and ecological receptor protection being applied in the greenhouse arena and the greenhouse dispute. So based on what I've seen in the last 20 years, it's critical to separate those topics. Environmental pollution, natural resources damage is one discussion. And we have proper standards, we have a lot of knowledge worldwide. The Environmental Protection Agency in the United States has developed great guidelines and science-based standards for different contaminants and pollutants. So I think we're making a lot of progress on that. It's important for us to develop for companies, private industries, mines, and energy companies to evolve with the climate arena. It's important to separate those topics. Some of the folks that spoke before here, they mentioned some of these lawsuits, the climate change lawsuits that are undergoing Brazil, and I've participated in some of them. And what I've seen is like a mixture between those two topics. So one of the first insight, the engineering-based insight, is that companies should target the zero carbon goal by 2050 or even earlier than that. Companies should invest in controlling greenhouse gas emissions, in maybe sequestration projects, and compensation projects for their emissions. But also, it's important to be fair with companies, with private sector mainly. They have a huge huge contribution to the economy. Here in Brazil, we need investments, we need our economy to evolve, and it's important for these stakeholders, for the investors to be prepared and to know what they are expecting moving forward. And from the game theory arena, which is my academic experience, we have different theories that can contribute for this discussion. We have the Nash equilibrium, so it's kind of hard to reach an equilibrium when you don't have an incentive to change your strategy. So if you're a company operating in Brazil and you're competing with a company, and Brazil has good standards, good greenhouse emission standards and good practice, good methodologies, let's say that's the case, and then you're competing with a company that, it's producing goods in another country and they're not submitted to the same regulations, it's really an unfair game. So that's something you have to keep in mind. And according to Nash, the private sector will not have incentives to change their strategy. And we're going to keep the status quo. In terms of the tragedy of the commons, Garrett Hardin came with this theory back in the 60s. Eleanor Ostrom more recently was awarded the Nobel Prize. And they also mentioned that, so the tragedy of the commons basically, it's a simple story that you have a pasture, and then if everybody brings their animals to be raised in that pasture, all the grass will be gone, and there will be no more resources left. So it's critical to establish a governance for this. They call this the CPR, right? The Common Pool Resource. So it's critical to include and consider design principles to properly manage these resources. So in this case, the resources, how much can I emit in terms of CO2, or how much can I emit in terms of other greenhouse gases? So everybody, if you have a car, you're actually responsible for some of that. If you have, if you are investor in a company that emits CO2, indirectly you also participant in that situation. So what are the strategies that Ostrom listed that we can maybe apply and include in our strategy for the next 20 years? And she listed like a strategy composed of 8 steps that I'm not going to be talking about here at this moment, but basically it's really critical to work on a local level. So work on a global level, it's critical. I think it's important, all these efforts, and to come up with agreements that everybody will play by the same rules and everybody agrees on some basic principles, but it's also critical to have local and strong coordination between the different players of this game. So community, companies, environmental agency on a local level. So managing a project like this, let's say Rio de Janeiro wants to implement a strong greenhouse gas strategy moving forward and be the #1 city in the world, the best example in the world. Everybody will have to gather locally and work together under the Rio de Janeiro reality, right? It's got to be done that way. Romulo and I just been in the Netherlands recently and went to Amsterdam and Rotterdam on a legal case as well, and we got to see some of the structures in the Netherlands, and they have this Delta program for the dikes in the Netherlands. It's a very interesting program that different stakeholders, they come up together with a strategy to manage all these floods and to protect the country from floods. And the local community, they have a lot of power, I would say, or freedom to take the measures that are needed at that time. So I think that there's many cases from the theory that we can apply, like game theory, practical cases like this one in the Netherlands that we can also consider. And I'm from a city that's called Petrópolis. I don't know if you heard of the city in the mountains of Rio. So over the last 40 years, 40 plus years, I've been experiencing, and friends and family have been experiencing climate events. It's a city that was built in the mountains, so a lot of landslides, big rain events. And one interesting story that about 30 years ago, there was a huge landslide there. And I remember that we weren't able to drive in this road for I don't know, a year maybe. We had to take a back road, a dirt road, because the road was completely blocked. And there was one house there, and the city of Petrópolis told this family they had to leave because it was too risky. And 20 years later, or 30 years later, this family is still there. And not only that, but, like a little mall grew up in the same area. And, there was nobody at the time when it happened. Now there's probably 40 or 50 people in this specific area. So what's my point here? My point is that we have a tough time thinking ahead. And in order to think ahead, we need cooperation. That's one of the premises of NASH as well. We need cooperation. We need different stakeholders working together. Like this case in the Netherlands, maybe less politics and more engagement, more coordination, in a citizenship level. I think citizens, it's critical for citizens to engage. So to conclude my talk here, I think that it's great to have all these goals, and I think we should pursue all these goals. We're already having a lot of discussions in the legal setting. In terms of legislation, I think we're still a little behind. We have to move faster. But what if Plan A doesn't work? What if we're not able to achieve these targets that we must achieve in the next few years? What's the Plan B? What's the Plan C? So I think it's really critical to think about alternatives and in a local level. Also, I think that we need market incentives. So we need to remember that we have a huge debt in the world right now, public debt. Most countries in the world have a significant level of debt, and there's no public money. That's the reality. There's no public money. So how can we create market incentives? Instead of taxing, how can we remove taxes? Instead of having punitive fines and multi-billion lawsuits, how can we work together and come up with a new model? I've been working for the last 20 years on litigation on natural resource damage. And what I can tell you is that it's costly, cause a lot of stress. Sometimes it solves the problem, but not all the time. And it's not good for the economy. I think we have to come up with, learn from all these lessons from the past. So the reflection that I leave is like, should this be a top-down or bottom-up strategy, and in order to come up with these alternatives? And one reflection that I discuss a lot with my wife, and she is a teacher and she talks about this every day. She's very committed with climate change and how can we improve things, and what have kids been learning. So I think it's something also we should think about, you know, teaching our kids and also working with schools, working with young generations, because without that, it's impossible to reach our goals in the future. So thank you so much, and a great event for everybody.
Well, thank you so much, Thiago. It was very inspiring. We're going to open and close this panel with engineers, but now it's time for the lawyers. So, Marcio, please, you have the floor. Thank you so much for being with us.
First of all, thank you very much for the partnership here at FGV, Pace University. It's a pleasure to be here. I will switch to Portuguese. It's more comfortable. I know there is a translation, simultaneous translation, so let's start.
My first point is about perception. I think that we experienced previous than pandemic, the moment that changed the perception of worldwide reality, the perception of the risk. When we think about climate change, we have a risk perception that is important for the corporate world, the business world. This perception of risk has changed, and that influences regulation. When you talk about accountability and risk management in the corporate world, I came from a company that had this experience, and I participated in other forms of reporting information. And the perception of the risk changes when you start to size that risk. And this is essential for regulation. Today, the first point that I would like to call your attention to is this movement of regulation. And an example of that, I believe Alessandra is going to talk about this, so I'm not diving deep on that because I will leave it to you. But is the CVM resolution here in Brazil, 93 of 2023, that gave opportunity to bring elements from regulations that are done in Europe and in other countries, the S1 and S2 modeling of accountability, to be able to measure this risk and to bring this risk to CAPEX, OPEX, and to have a more concrete data for the investors to look and have a comparison between companies and different competitors that are in the market. In Brazil, there are 4 companies that has announced that they're going to do this voluntarily. And this is an interesting movement. The sensitive sectors as the mining sector. And this is an example on how the information part and the disclosure of information and the delivery of data, in my view, it has the role to reduce the behaviors and the views and to involve competitors and to enable a competition compliant to the new desires of society. This is one point. The other point is from the previous panel, and it is a more mandatory report regarding soft law and hard law. For example, the case that Fernando Tanuri mentioned of CETESB that's regulated to make an inventory of emissions. And CETESB is the environmental body of São Paulo that tries to combine the air quality, control, and strategic parts. And what are they going to do with that? It's not very clear, but this is the first step. We have the CVM, this reporting of information. We have environmental body. The CVM is the Security Exchange Commission, and each one in their own area with different objectives. But this is going to pave the way for the information. So the regulation nowadays is in this sizing of the risk. And this is important for the company to guide and establish a market strategy in order to reach what we call the net zero and other goals that make sense for that organization. This clarity to have different ways, this formation process tends to help to build this or to pave this way. And the judicial part, somehow, as it was mentioned here by Tiago and by the previous panel, somehow we leave a discussion in the judiciary of modulation of public policies that contributes, as we see the examples of other countries, the drafting of public policies that are going to affect the companies. I had the opportunity to work in a case last year in the structuring of the decarbonization strategy of a specific sector. And I wanted to bring as an example, because it is a public case that was publicized by the customers in the social media, and it is at COP being discussed. So there's no problem in disclose this information here. It's in the website. If you want to log on the Move Infra website, there is a study that was published. That is this map here, so I can show you later. The decarbonization of the infrastructure and logistics sectors that shows a little bit of how these regulations and how the market induces a strategy on how to deal with the risk and how to see the risk and try to size it and advance on a business strategy. All this called my attention because when we were contacted, a group of companies and an association requested a decarbonization study with strategies for the decarbonization of a sector that was not mapped by the government as something that was target for decarbonization. The infrastructure and logistics sectors has concession of ports, roadways, railways, heavy infrastructure that the focus is adaptation and resilience and not decarbonization. Decarbonization is in the transportation sector, here in Brazil in the case of motorization or biofuels, and other sectors affected by the decarbonization sector, as the energy sector and the land use. But while starting this study, we selected 3 complementary axes. When an organization looks at the decarbonization process, it has to look at the public policies arena, where my sector inserts itself in a public policy. And the first point that we identified is that this sector was not contemplated. And we claimed the Ministry of Environment, and this sector became contemplated in the climate plan, but with a specific strategy to decarbonize, this is their main problem, not scope 1 or scope 2, but scope 3. We had to take a proposal that is a difficult scope to limit that involved the production chain. If you look at infrastructure or the greenfield projects, how much we are going to implement, you have to see the supply chain. And this is an instrument used in the infrastructure to be decarbonized. And this was one of the strategies that was established in communication with the sectors. Another point is how do I use the regulatory instruments to help this decarbonization process with contracts that are in force and some other contracts that I have to adapt, as the permits in the act of concession, or the tariff, or the financial economical balance, and how do I account for the climate risk in these contracts? This was an interesting discussion that resulted in an operation of an ordinance of the Ministry of Transportations that introduced the climate risk, allowing to abate the permits in a location depending on the investment that was done in a certain concession. We use the existing instruments to address this risk and allow a balance where there is an engagement of public policy and the dealer and the utilities. Another interesting point was how to leverage the investments in this sector, how to fund this. When you look at the main instruments of financing in the country, they are focused on electrification and biofuels and energy in general. Nothing was associated with adaptation, but the decarbonization of this specific sector. And then there was a proposal that is being studied by the BNDES on how to fund this type of investments in the sector. And we work with three main axes: public policies, specific instruments of that sector that regulate that sector, and instruments related to financing. No one talked about licensing, although the conversations in the state governments in Brazil, the issue of licensing always came as command and control, and it is a more disputable agenda. Just to summarize here my point, the decarbonization with a net zero agenda, with an accountability of the companies, demand sizing of the risk to understand where you are inserted in terms of regulatory framework, to understand why so many public policies are being made, and the agencies that influence the public policies and judiciary power is an important agent, and they solve the bottlenecks of these policies. They end up in the judiciary, and we are lawyers, and we feel that every day. But the company needs to come up with a strategy to look at its organization, to understand their weaknesses. And in this case that I mentioned, as a positive example, I put some companies that were there and said that my main shareholder is from Europe or in another country, and they already have a rule on decarbonization, and I need to influence positively Brazil in order for us to achieve results that I can take to my shareholders, both in terms of information and to meet the targets and strategy and implementation of the decarbonization sector. It is a market that influences the regulation, inducing the government to act collectively. I think this is a good recent example here in Brazil that it's worth mentioning. We have to mention the good examples. There are many other cases that with judicial disputes, and we know that this feeds our everyday, and these important initiatives meets exactly the point of the panel. So I'll be available for questions later.
Thank you very much, Marcio, for a great example of corporate accountability and partnership with the government. I will now, before I go to Belém with my dear friends, I will handle the floor to Alessandra Lehmann. She's the co-chair of the Climate Law and Governance Initiative, a great friend of FGV, and one of the most renowned climate change law professors in Brazil. Thank you for being with us. You have the floor.
Bom dia, good morning. It's wonderful to be here. I would like to start by thanking you so much for the opportunity to discuss a subject that is so dear to me, both as a private practitioner and as a law professor. Hearty thanks on behalf of the Climate Law and Governance Initiative to our hosts, Professor Romulo, also to Emmanuel. For our theme today, corporate accountability, I wanted to start by saying that there is most definitely a lot going on. So I would briefly like to make 7 points on relevant trends and developments for corporate climate action, and I promise I'll be brief and we're pressed for time. I guess my first time would have to be disclosures. Marcia just mentioned the adoption of the IFRS S1 and S2 standards in Brazil. So there was this strive for harmonization and comparability, and this effort materialized recently as of 2 years ago in the IFRS S1 and S2 standards. Brazil is arguably the very first jurisdiction to adopt in a mandatory fashion those standards. So I think it's important to realize that what started as voluntary standards are now mandatory for Brazilian publicly traded companies. What I also like to highlight with regard to disclosures in Brazil is the fact that we are witnessing a second regulatory movement with regard to disclosures. So from the model of CVM number resolution 59, which established a comply or explain approach, we have now evolved from a standard of reasonable assurance, which is key, of course, for climate risk and opportunity management from corporation standpoint. My second point today is this is something that's quite prevalent in our practice, I think, and also in corporate life, which is transboundary implications of what I like to call the EU sustainability arsenal. So, which comprises the EUDR, CSDDD, CBAM, the Sustainable Taxonomy, the Horizontal Cooperation Directive, Anti-Greenwashing Directives, the Environmental Crime Directive, which are currently under review in the context of the omnibus proposal, but also bear implications, cross-border implications, including for corporations in Brazil. So this means that economic agents adjust either by conforming, and we have examples of this sort of Brussels effect of sorts in Brazil. For instance, we have regulation by the Federation, self-regulation by FEBRABAN, which is the Federation of Private Banks in Brazil, which pretty much prevents those who adhere to those banks who adhered to the initiative to finance the meat industry when production is made with at the expense of illegal deforestation, or by pushing back. So we have a reverse Brussels effect of sorts. For instance, the law of reciprocity, which was recently passed in Brazil. My third point is implications for litigation. So basically, more information available by means of disclosures also means more scrutiny. And as a result of, among other factors, the type of regulation with transboundary effects I just mentioned, we have seen climate litigation with increasingly transnational features as well. My fourth point is the emergence of a Brazilian emissions trading system. As of December last year, law number 15042 finally implemented a cap and trade market in Brazil, which ultimately means that Brazil is for the first time effectively putting a price on carbon. So for the sectors of the economy that will be covered by the regulated market, which of course we still have at least 5 years ahead of us until it's fully implemented. But for those sectors, this means they will necessarily need to start to think in terms of internalizing their GHG related externalities. Fifth idea is the idea of financed emissions, and taking it a step further, also the idea of advised emissions, meaning that the scrutiny that I just mentioned that has been picking up pace in some jurisdictions, at least, with regard to financial institutions and advisory firms, in the sense they are scrutinized for the climate impacts of the projects and activities that they finance or advise. So this is definitely something to keep on our radar, particularly as private practitioners. The sixth idea that I wanted to discuss today is the idea of disasters and contingency plans to deal, corporate contingency plans to deal with said disasters. Disaster contingency plans are mandatory in Brazil at least since 2023. So this also means that companies need to invest in climate adaptation and resilience, particularly in light of the extreme climate events that have become increasingly more frequent and also more devastating in terms of their effects. I think my home state of Rio Grande do Sul is an example of what I mean in terms of physical climate risks. And this also as a means to preserve value for investors and shareholders. And finally, as I'm a lawyer, I would like to highlight in my seventh and last point, the effects of the recent climate advisory opinions by international and regional courts and their impacts, potential impacts for the private sector. So quite recently, just to contextualize, we have three climate opinions, advisory opinions that were delivered first by the International Tribunal for the Law of the Sea, second by the Inter-American Court of Human Rights, and finally by the ICJ. So repercussions for climate actors are pretty much materialized in the fact that all of those decisions have, in advisory opinions, have in some measure considered explicitly the participation and the importance, the relevance of the private sector in the fight for decarbonization of the economy. The ICJ did not recognize direct corporate obligations or elaborate on extraterritorial regulation or specific legal consequences for a state's failure to regulate private actors. But what it did was to note that a state may be held responsible for failing to regulate private actors' GHG emissions, even if the conduct itself is not directly attributable to the state. Another thing that I find interesting from a private lawyer standpoint is the fact that it recognizes the normative content of the Paris Agreement, Article 4.2, which basically states that states have a due diligence obligation to implement domestic mitigation measures, including for private actors, which makes sense as decarbonization does not happen in an economic vacuum. We also see mentions to state obligations to extend private sector activities that impact areas beyond national jurisdiction. Also mandating environmental impact assessments for private activities, considering specifically downstream climate impacts, even if these occur in other jurisdictions. And also the Inter-American Court has something along the same lines, stating that states must enact legislation requiring companies to conduct due diligence to identify and address climate-related impacts across their entire value chain. So here we have the transboundary element again, this time highlighted in the advisory opinions. So the general idea, and I'll stop here, is there's a constantly evolving and increasingly transnational landscape when it comes to corporate climate accountability and governance, which prompt corporates and their advisors to follow these developments closely. Thank you.
Thank you so much, Alessandra. 7 great highlights and news from Brazil and abroad. And without further ado, I'm going to now travel to Belém, where we have two dear friends, Fábio Flores and João Irineu. Well, let's start with Fábio. Fábio, thank you for hosting you in your beautiful firm. You have the floor.
Thank you, Romulo. Good morning, everyone. First of all, I'd like to congratulate Pace University, represented here by Professor Michael, and FGV, represented by Professor Romulo. And it's an amazing event that we are hosting here. We have the honor to host the opportunity of participating on this great event. And I would like to thank Romulo for the kind words he said yesterday on closing remarks and the compliments he made for our partners and our office. And Romulo is a great friend, and I feel really bad for him because he's not here with us. He doesn't have the opportunity of having a good bowl of fresh açaí, or having a hot tacacá with a lot of jambu until he gets his mouth numb, or listen to our great music, the brega, the carimbó. And but it's important, as was said yesterday by Dr. Jorge Alex, the hosting a COP here in Belém is a statement, not only for the importance of the Amazon forest, but how the climate discussions are held and how it's important our participation as a community. And when you're trying to establish some environmental politicals, you need to hear the communities. And the Amazon people are usually forgotten. So the fact that we are holding this kind of event here is very important for everyone. So the COP brings the Amazon to the very heart of the climate discussion nowadays. And when you talk about net zero targets, it's impossible to talk without talking about the forest itself and how we're gonna stimulate some kind of green economy and help the people without leaving them beside of the development. And when we talk about the corporate accountability, we need to talk about transparency, responsibility, and the consequences. And it's not about the neutral carbon targets, but also how, where, and with whom they will achieve this kind of commitment. And when you talk about the accountability in the Amazon, we have a deeper meaning because it's evolved respecting social and environmental laws and rights and ensuring the consultation of the indigenous and traditional people, and also avoiding the territorial greenwashing when with the projects that claim to save the planet, but they don't give any benefits to the people that are living and preserving the forest. So the accountability must comply and combine with social justice, ecological integrity, and respect for local governance. So this climate action can be legitimated and not imposed to the people. Amazon stores something around 120 billion tons of carbon. So we cannot talk about net zero without talking about the forest. And I like to bring the Amazonian perspective. That's where we stand. And much of the corporate offsetting strategies depends exactly on the projects on the Amazon. And it still lacks a lot of transparency, governance, and tangible local benefits. We should see the Amazon not only a carbon stock, but also a driver to climate innovation through the bioeconomy, sustainable valuable chains, responsible forest management, and clean renewable energy, that Brazil has all the opportunity to be a leader on this matter, because we have the sun, we have the wind, we have the water. So we have a lot of opportunity to be a leadership on this matter. And the forest has to become a new symbol of the green economy. We cannot think about conservation without thinking about creating value to the people here. It's a living territory with knowledge, culture, and opportunity that we need to observe. And we see, it was mentioned before, some net zero goals until 2050 that are very ambitious, but we still need to see if it has to be very clear about the verifiable about this transitions plans, because we see a lot of the carbon offsets that often hides the absence of real emission reductions. So you see the developed countries is still the industrial production, and they are demanding that the people in the forest don't have the same development, but keeping the forest up, and they still keeping the emissions while the people here cannot do the same in order to development. So this kind of scenario creates a risk with the projects with no prior consultation to the people, double counting of avoided emissions, and some compensations that brings no social or environmental benefits to the people. So we need to construct a stronger legal institutional government for corporate climate action with mandatory climate due diligence, transparent reporting, and independent verification, because there is no true net zero without zero accountability. So the path towards the responsible corporate climate action relies on 5 points: transparent governance and carbon projects and supply chains, alignment with national and regional public climate policies, promotion of bioeconomy and science-based innovations, inclusion of local and indigenous communities in decision-making and benefit sharing, and a mandatory and verifiable climate reporting supported by independent auditions. So the company that can see this as an opportunity, he not only achieve their carbon neutral goals, but also will build a trust, legitimacy, and a long-term resilience on a low carbon global economy. And that's something I'd like to bring, and I thank you for the opportunity.
So much, Fabio, for your kind words. Don't worry, after COP30, I will be there to do all the things you said, because you know how much I love being there and how much I love the food there. So without further ado, as I promised, let's close our panel before our youth commentator in New York with João Irineu, a good friend and engineer who makes cars, and he's going to tell us how he is going to drive accountability to net zero. João Irineu, thank you so much.
Good morning, good afternoon. First of all, thanks for the opportunity. It's our second time with you guys, and it's great. Let's try this one. Does it work? Yeah, okay, thank you. Now let's start again. So thanks for the opportunity. It's a great honor to be here. It's my second time at FGV, and mainly to discuss decarbonization process that's a huge challenge that we are facing in the last years. As you mentioned, my name is João. I'm in charge of regulatory affairs inside Stellantis. Stellantis is the market share leader in passenger and light commercial vehicles in Brazil and South America. So great responsibility in terms of decarbonization process. And everything that we are going to share with you on the next slides is related to the cradle to grave evaluation. So scope 1, 2, and 3. It's the whole life assessment of the business. And the great challenge is to make a decarbonization process in a balanced way, in a sustainable way. Sustainable means environmental, economics, and social. So we are in a underdeveloped region. The technological evolution should be done in a way that we can use all the resources that we have in terms of low carbon opportunities. So let's start with the first slide. I will pass a little quick on the first ones. We have 6 plants in South America. We have 30% of the market share in Brazil and 23% of market share in South America. So we have 4 development centers in South America. That's really important because that gives us the freedom to design cars down here. So most of the cars that we sell here, and I'm going to show you later, are designed by Brazilian engineers. So we have the opportunity from a blank piece of paper to design the whole car, develop the car, test the car, homologate, certificate, and sell the cars down here. So that's a great honor for us. The main brands are Fiat, Jeep, Peugeot, Citroën, and Ram. Let's go to the next slide, please. This is the portfolio. As I mentioned before, it's a great responsibility for the decarbonization process. The portfolio that we produce down here goes from A segment, entry-level cars, the cheapest one, to the most expensive one. So we see Mobi in the middle with the brand Fiat, and we see Rampage. It's a pickup, light commercial vehicle. So all those cars, most of those cars are designed down here in Brazil by Brazilian engineers. So let's go to the next one, please. So the auto industry has many challenges, many regulations. The main challenge is the first box. We have here 10 boxes. Those 10 boxes, they represent the main challenge that we have. But the most important one is the first one. It's the decarbonization process of the whole industry, from cradle to grave. The car has 5,000 components, and the life cycle starts on the mining, iron, bauxite, many minerals that we extract from the nature in order to put together the raw material, manufacturing the components, bring the components to the plant, to the assembly plant, produce the cars, sell the cars to the customer run the car. In Brazil, it's roughly 200,000 kilometers for a passenger car, 200,050 kilometers for a light commercial vehicle. Many owners in this path, right? The first owner, the second owner, the third owner, and you go to the end of the life cycle of the vehicle, end of life, recycling process. So if going from the mining process at the beginning to the end of life on the recycling process, you have the whole life cycle of the vehicle. So we need to take care of the whole process. Many sectors are involved on those processes. So the first box on the left side at the upper position, the energy efficiency or the decarbonization process is the most important, but we have others. So let's go to the next slide, please. Many regulations for all those challenges. We have different regulatory timeframes that we discuss with the government, different agents on the government, different ministers, class associations, automaker associations, parts associations. So different discussions, not easy, in order to find the right regulatory landscape in order to be competitive at the same time. So sustainable in environmental perspective, economic perspective, and social one. Let's go to the next one, please. The investment of Stellantis in South America is 32 billion. It's a 5-year investment. It goes from 2025 to 2030 in order to develop the technologies, to develop the supply chain, and decarbonize at the same time. So let's go to the next one, please. As I mentioned before, the main challenging, we've tried to summarize it in 4 boxes on the same slide. The box on the left side at the upper position, we see the growth of the usage of the fossil fuel on the industrial from the past from pre-industrial to industrial phase. So fossil fuel growing up exponentially. Second box from the left to right is the temperature on the Earth's surface, so 1.5 degrees Celsius roughly. The third box, a really important one, how many CO2, equivalent CO2 we are putting in the atmosphere as a global? It's 50 gigatons per year. We are throwing in the atmosphere 50 gigatons of CO2 equivalent. If we do nothing from 2025 until 2100, so 75 years from now, it's going to be double or triple. 50 will be 150 or 200 or whatever, or 300. So it's huge if we do nothing. That's the pink zone, worst case scenario and best case scenario that to put on the third chart. Consequence, on the right side, at the upper position, last but not least, we see the equator line, close to the equator line, more than 40 degrees Celsius every single day of the year, and high humidity on that area. So scientists, they estimate a zone that we cannot survive, that the red zone to see. And we look to that zone, we see it's where we produce food, animal and from vegetal, to food, to feed the world, right? So we see countries that have more impact on the CO2 emission that we're going to see on the next slide. But that's the consequence that we have if we do nothing, right? That's the worst case scenario. Let's go to the next one, please. Those are the countries that are running in order to mitigate. In absolute numbers, that's one way to show it. That there are different ways to show the numbers, but that's one way. We see China, US, Europe, India, and Brazil. I mentioned 50 gigatons. If we split those gigatons across the main countries, we see China is the first one on the emission, US the second one, Europe the third one, India. Brazil is probably in the 9th position. But the most important thing that we can highlight here is not the absolute number, is the profile of emission on Brazil. The others are, the main emission is concentrated on energy generation. Brazil has a different profile. So the blue zone that you see on the left side for the first 4 countries, Brazil is the third. We have another issue, the usage of the land. The second one is agriculture and cattle. The third one is energy generation, and the fourth one is transportation. It's our business, right? So let's go to the next one, please. We have also good news, not only bad news, but this is the energy matrix profile. Brazil, the upper portion of the graph, the green, I see green here. I'm not sure if you are seeing green, but the green portion is a low carbon energy generation, and the pink or red one is the high intensity carbon. So Brazil is 50-50, roughly, the whole energy metric. So that's good news. So we can use and develop more quickly the lower carbon energy generation. The next one is the, next slide, please. The other good news is the electricity generation. Our electricity is based on hydro plants, biomass, mainly from sugarcane production. The third one is wind, and the fourth one is solar. So roughly 90% of our electric energy generation is low carbon. That's the second good news, right? We see also Norway is pretty close to Brazil on hydro. So Norway is almost dot of the line in Europe. It's a pretty interesting country that we are going to see more data from Norway. Let's go to the next slide, please. So most of the rich countries are moving on the transportation, passenger and light commercial vehicles to the full electric vehicles, the BEV, battery electric vehicles, as a solution to decarbonize. Norway is, again, I want to highlight it. They have a long plan. They are working a lot on the transitioning to the full electric vehicle, and the mix of the full electric vehicle on the sales is close to 90%, as we can see on the upper graphic. The graphic below is car fleet, the mix of BEV vehicles, the battery electric vehicles on the car fleet, what's running inside the country. So again, Norway is a dot of line. Brazil is, we see on the green line, it's in a good position for the passenger cars for a simple reason. We have ethanol. Ethanol is a low carbon fuel. When you burn ethanol in an engine, it generates CO2, like the gasoline one, but it's captured by the sugarcane plantation that will produce the next batch of ethanol for the next year. So as 30% of the fuel that we use on passenger cars, 30% is ethanol. So 30% of our fleet runs with ethanol, and so it's low carbon. We are pretty close to Norway. We don't have a bunch of BEVs because we do not have charge infrastructure. This is a continental country. Norway is a small country. It's more easier, let me put this way, in order to install, but they plan that stuff for a while. And it's a rich country. We are underdeveloped country. So we have more challenges in order to reach this mix of BEVs. But instead of that, we have the ethanol to decarbonize in a more sustainable way. So CO2 is a global issue, but we need to find local solutions in order to be sustainable, right? So let's go to the next one, please. In order to follow the targets that we are putting together for the Brazilian region, we need to draw a line from now until the net zero in 2050. And we know, based on the technologies that we know right now, in a cradle to grave perspective for the automotive industry, it's going to be pretty tough to mitigate 100% of the CO2 in 2050. It's going to be a small portion that we do not have. We do not see technology today to mitigate it in 2050. So we are going to compensate CO2. We will need to find ways to capture CO2. And we have two ways to do that. Natural one and not natural. Natural is physical, more investment to capture CO2, chemical solutions. And natural one by the usage of the nature that we are going to explain at the end of the presentation. So let's go to the next one, please. This is the life cycle of the vehicle. It starts on the left side at the upper position on the mining iron. So 60%, almost 60% of the weight of the car comes from steel and iron. So mining is important. And raw material, produce the steel is the second portion that's really important. And so we need to build the parts with our supply chain basis. We have at least 500 suppliers in order to produce the 5,000 parts of the vehicle. We need to transport those parts to the plant, and the small box in the middle with the car is our plant. This is our legal entity, okay? Second, we sell the car, and when we sell the car, the customer can run with 3 different sources. It can run with gasoline, it can run the car with ethanol, or can run the car with electricity if it's a full electric vehicle. And so at the end of life of the cycle of the vehicle cycle, we go to the recycling, the small box on the right side. So different sources, we can see a graphic on the right side. If you run the car with 200,000 kilometers during the whole life cycle, considering the CO2 equivalent emission from mining to recycling from the beginning to the end, the total it's going to be close to 60 tons of CO2 emission if you run with gasoline. If we run the car in the whole life cycle with ethanol, it's going to be 26 tons during the whole life cycle. If it runs with electricity in Brazil, so the BEV is not zero emission. The battery electric vehicle is not zero emission. There is no emission on the tailpipe because it doesn't have tailpipe, but you need the main emission of the BEV vehicle is on the battery production. So chemical, so too many components, chemical components, minerals, in order to be refined, mining, refining, and put together to build the cell. So when we see this graphic, we see ethanol and electrification are the lowest one, 26, 23 tons. This is the huge opportunity that we have in Brazil to combine ethanol with different levels of electrification. We don't need the PV in a highest volume, but we have the hybridization with the ethanol. If we put those together, we believe that's the best way to find the balance and the sustainable business for the transportation of passenger and light commercial vehicle in terms of environmental, economics, and social. Let's go to the next one, please. Some countries they decided to go from internal combustion engine to full battery vehicles. That's a huge challenging, because in this moment, you need to throw away all the manufacturing process for the engine, for the transmission, for everything, throw away and shift to the full electric vehicle. It's a different technology. It's completely different. So solution, and the main thing is the social, because we need to close the contracts for the employees that has no knowledge to work on the full electric vehicle. So the engineers, the engineers are prepared to build the engine, transmission, the system that works with the engine and the transmission. You throw away the lines, the tooling system, and also the engineers that in order to go to the full electric vehicle. So that's the main reason that we are saying that we need to find the balanced way in order to go the transition. The transition should be sustainable. And the solution for that, let's keep it going to the next slide, please. Our program is the biohybrid. It's the combination of the biofuel or ethanol and different levels of electrification. Let's go to the next one, please. I mentioned at the beginning, $32 billion in order to go from 2025 to 2030. And those are the different architectures from biohybrid, low voltage, mid voltage, the hybrid, the full hybrid, the plug-in, and the BEV. We are going to cover all the technologies spread in the portfolio that I've disclosed to you at the beginning. because we have A segment, B segment, C segment, and premium segment. We need to spread this according to the cost and affordability of the customer, and decarbonize the whole fleet. So different combinations, different architectures. We just launched. Can we go to the next one, please? We just launched the mild hybrid on the fastback and the pulse last year, and from now until 2030, all those architectures will be present in the portfolio that I mentioned at the beginning, in order to guarantee the decarbonization on board of the vehicle. Let's go to the next one. But as I mentioned, we are working on the cradle to grave. It's not sufficient to decarbonize, changing the technology on board of the vehicle. We need to work on the scope 1, 2, and 3, mainly the scope 3 upstream and downstream of our supply chain. So, and it responds for 50% of the CO2 emissions of the car, right? Let's go to the next one, please. There is an ecosystem that we put together in order to work for the net zero. And it includes green materials, the technology roadmap on board of the vehicle that I just showed to you, green energy for the plants, logistic for the transportation of the parts, efficient process on the production side. Production means also raw material. Raw material is really important, and I'm going to show you in the next slide. Sustainable in customer journey, incentivize the customer to use ethanol, because sometimes you are in a region that the ethanol has a low cost, but the customer keeps using the gasoline, so doesn't make sense. And circular economy. Okay, let's go to the next one. We analyze the whole parts of the material. Let's go to the next one. As I mentioned before, on the right side, the steel, aluminum are the main responsible for the emissions to build the car, the parts of the car. So we are working very hard with those guys in order to lower down the carbon during the production. Let's go to the next one. Let's go to the next one. I mentioned that's net zero, right? To do net zero, it's gonna be pretty hard to do the net zero from now to 2050. We don't have all the technologies, so we are working on CO2 compensation to capture CO2. And we have natural ways to do it and technological way to do it. Brazil is responsible for the natural way to do it. And one of the things that we are studying right now is the biochar. Let's go to the next one. Biochar, what's biochar? It's a carbon. We remove the peel or the rusk of the coffee. We have lots of productions of coffee here. And the rusk stay in the atmosphere in the composition, so we don't use it for nothing and throw CH4 in atmosphere. We collect those husk and peels at the farmers, burn it in a pyrolysis way, and we generate a carbon that's pretty intense. And we move back this carbon to the plantation, coffee plantation, improve the agronomic characteristics of the soil. And that gives 10 to 20% of production, improve of production, and reduce the dependence of fertilizers. So this is CO2 natural capture, carbon credits generation, circular economy. So it's pretty. We are investing on this biochar. And the last one, go to the next one, please, is the recycling process. We just put together at São Paulo City a center to dismantling the vehicle and use the material of the car to be recycled. That's one action. Second, parts that are used and we can keep using them, we sell those parts in the market. And we have obviously many opportunities. Let's go to the next one, please. it's a 30 million investment for the dismantling center, 80,000 vehicles that we can do per year. So that's a way in order to move, in order to avoid the mining and the raw material. We can use what we are from the dismantling center. We have a bunch of old cars that are not going to run anyway in the Trump parking lots and in the interior of the states. So many ways in order to mitigate the CO2. Let's go to the next one. Next one, please. We are closing. None of this is possible to do by ourselves. We need the ecosystem. So suppliers, governmental institutions, ICTs, universities, the whole team working together in order to make this happen. And the last slide, but not least, it should be done between private sector and public sector. We need to do laws, regulations, decrees, negotiations, and I just bring some examples of what we've been doing since 2012. And the main example is at the bottom. Free programs, 5-year programs that start in 2017 with the Innovar. It went to Rota 2030 in 2022. We just published the Mover that will be enforced in 2027. It's a free 5-year program. It's a 10-year time frame. And at the bottom, we see 12% reduction, 11%, 12%, 35 CO2 reduction on the Brazilian fleet in 10 years. It's going to be pretty tough to find a country, underdeveloped country around the world that achieve this amount. So this is a success example that we can do and explore in other sectors. So thanks for the opportunity, and we are open to discussions.
Thank you so much, João. It's great to know all of the things that are happening behind the wheel. It's a lot of information, and I think great examples for other parts of the world. And before I close this panel, I'm eager to hear from our youth commentator, Mackenzie Sherman from New York City. You have the floor. Thank you so much for being with us and joining us from New York.
Thank you for having me, and thank you to the panelists for highlighting so many important topics. I want to just touch on some of the thoughts I had while listening to this panel from a youth perspective. I would like to start by acknowledging that as social media has expanded, so has a sense of connection that runs through our generation. The panelists touched on corporate risk, climate and greenwashing, and disasters, and so many other topics. In today's world, a disaster hitting across the world is seen in a matter of seconds at our fingertips. This makes these impacts feel all the more real, and the need for climate accountability becomes even more imperative. Net zero targets have been an ongoing topic for many years now. But as we approach 2030, 2050, what was once this far-off goal is now something we are actively facing today. It's not enough for us to talk about plans and goals. We must also talk about real action that's being taken. These changes, decarbonization rather than mere mitigation. As we push for this active role, we ask that the new generation take a step forward and be a part of this. Thank you.
Thank you so much, Carrington Lowe, for your insights from New York City. It was great having you with us. Because we are so pressed with time, Emmanuel, who is keeping me on the leash here, has told me that we need to close the session, and we'll have a 10-minute break before we resume from Belém and the Zoom. Thank you so much.